The development of legal systems forms a central element in the history of human societies, documenting the shift from basic social rules to complex mechanisms that regulate conduct, settle disputes, and maintain order. Central to this process is the requirement to manage essential features of human conduct, including safeguarding reputation, curbing intrusive actions, and establishing consistent treatment in interactions. Initial laws arose from the demands of group existence, where unregulated behavior led to instability, and they progressed into organized sets that reconciled personal liberties with group requirements. This progression mirrors advancements in technology and organization, as well as changes in concepts of ethics, governance, and obligations, altering laws from commands linked to higher powers to tools for societal management. With the move from mobile lifestyles to fixed agricultural settings, laws started to define remedies for issues like untrue statements or repeated disturbances, which eroded reliability and cohesion. These initial measures frequently originated from spiritual or sovereign sources, stressing penalties and structure, and they established the basis for detailed safeguards against personal violations. As time passed, the range grew to encompass defenses against organized disparities and exploitative arrangements, prompted by initiatives that identified systemic issues. This growth points to a key dynamic in legal records: the ongoing adjustment between upholding structure and responding to developing standards, such as identifying effects of directed actions or unwelcome conduct. The consistency of specific bans across societies, such as those on fatal force or asset seizure, indicates common human focuses on existence and equity, whereas differences in application show regional variations. In reviewing this path, laws appear not only as reactions to problems but as active influences on human connections, creating conditions where examination and exchange can proceed without leading to disarray. This opening summary prepares for a thorough review of legal beginnings and changes, disclosing trends of alignment in recent times alongside continuing distinctions from past settings. Ancient foundations of legal codes. The first indications of law in human history emerge in prehistoric societies, where informal norms guided small groups through consensus and communal enforcement. These proto-laws, inferred from archaeological findings and observations of existing indigenous practices, addressed essential requirements for survival, including limitations on internal disputes and improper use of resources, implemented through mechanisms like banishment or compensation. As agriculture enabled the formation of larger populations around 10,000 BCE, these norms transitioned into more structured directives, particularly in river-valley regions, where the demands for coordinated efforts and distribution of possessions required precise instructions to mitigate disagreements. This shift marked the beginning of law as a deliberate tool for maintaining order in expanding communities, evolving from spontaneous reactions to intentional frameworks that supported collective activities and reduced potential for disruption. In Mesopotamia, the Code of Ur-Nammu, dating to approximately 2100 BCE, stands as one of the earliest complete written legal compilations, prescribing fines for violations such as capture and underscoring safeguards for specific individuals, which demonstrated an emphasis on royal adjudication and economic continuity. This code paved the way for subsequent developments, including the Code of Hammurabi around 1750 BCE, which incorporated principles of reciprocity such as lex talionis for physical damages and supervised areas like trade and domestic arrangements with sanctions adjusted according to social standing, revealing a stratified arrangement where outcomes depended on one's position in the hierarchy. Parallel progress occurred in other civilizations. Ancient Egypt's Ma'at principles, originating in the Old Kingdom around 2686 BCE, fostered equilibrium through decrees issued by rulers concerning taxes and labor, integrating divine oversight with practical adaptability to ensure administrative efficiency. These ancient legal compilations revealed both common threads and distinct variations. Universal components encompassed prohibitions on taking life and appropriating belongings, highlighting collective human objectives for preserving existence and control over assets, while unique characteristics, such as the communal orientation in early Chinese Zhou customs around 1046 BCE or the emphasis on conduct in Hebrew Mosaic law from the 10th to 6th centuries BCE, accentuated adaptations tailored to local conditions. The Indus Valley's implied regulations around 2600 BCE, derived from consistent artifacts, suggested uniform guidelines for exchange, contrasting with Mesopotamia's tiered structure and illustrating how environmental and social factors shaped legal expressions. Across these examples, the period established law as a mechanism for authority, progressing from verbal traditions to documented pronouncements that disseminated rulings and discouraged infractions, thereby solidifying governance in nascent states. In total, this foundational era set enduring precedents for legal systems, where the codification of rules transitioned societies from reliance on ad hoc resolutions to reliance on established texts that could be referenced and applied consistently. The emphasis on penalties and protections in these codes reflected practical responses to the challenges of population growth and resource management, ensuring that laws served as instruments for stability. As a result, ancient foundations influenced subsequent legal evolutions, providing models for balancing retribution with regulation in diverse cultural settings. Classical and medieval transformations. In the classical period, legal frameworks acquired greater conceptual breadth and extensive application, enhancing previous compilations through analysis and broadening. In ancient Greece, Draco's Code in Athens around 621 BCE enforced rigorous sanctions for lesser infractions to restrain excesses by the elite, while Solon's modifications in 594 BCE incorporated relief from obligations and participatory features, bolstering assembly systems that extended adjudication. These enhancements highlighted affiliation and pacts, guided by examiners who regarded law as a route to collective equilibrium. Rome advanced this course with the Law of the 12 Tables in 451 BCE, granting accessible reference to civil privileges and succession guidelines for general populations, advancing into the Justinian Code of 529 to 565 CE, which assembled prior rulings into a methodical assemblage. Roman law's functional method, encompassing ius gentium for dealings beyond borders, impacted later arrangements by preferring established cases and versatility in an expansive territory. Concurrently, in other streams, laws merged worth elements, as observed in the Hebrew, focus on hallowed pacts forbidding disloyalty and incorrect testimony. The medieval period introduced separation and oversight by faith after Rome's fall. European systems based on land from around 500 CE relied on traditional laws and property courts for terrain and worker disagreements, reaching a high point in England's Magna Carta of 1215, which limited regal control through appropriate procedures. Canon law, established in Gratian's Decretum around 1140, oversaw religious concerns like partnerships, while Islamic Sharia from the 7th century combined holy directives with set consequences for violations. Hindu Dharmashastra documents, prominent by the medieval era, implemented function obligations with result-oriented adjudication. This era's laws, often dispersed and centered on conviction, countered classical unification, yet they retained primary halts on aggression and appropriation, altering them to faith-based environments and indicating a transition toward group principles over solitary claims. In summary, the classical and medieval transformations expanded the scope and depth of legal systems, incorporating philosophical insights and adapting to new power structures. The integration of debate in Greece and precedent in Rome provided tools for flexibility, while medieval decentralization emphasized habitual and spiritual elements. These changes ensured that laws continued to evolve as instruments of governance, responding to the demands of empire, faith, and feudal organization. Enlightenment and industrial reforms. The Renaissance and Enlightenment periods represented a decisive turn toward secular legal development, propelled by humanistic perspectives and systematic reasoning. Beginning around 1500 CE, the Reformation directly challenged ecclesiastical authority over legal matters, enabling secular authorities in Protestant territories to assume jurisdiction over domestic issues such as divorce and inheritance. This shift reduced the dominance of canon law in everyday governance and opened pathways for civil legislation that prioritized individual autonomy over religious doctrine. The invention and widespread adoption of the printing press further accelerated legal evolution by making texts accessible, allowing for broader dissemination of statutes, commentaries, and precedents that previously remained confined to manuscript copies or elite circles. English common law underwent significant consolidation during this era, relying increasingly on case-based precedents to address contracts, offenses, and property disputes. William Blackstone's Commentaries on the Laws of England, published in the 1760s, synthesized these developments into a comprehensive framework that emphasized judicial interpretation and adaptability rather than reliance on rigid statutory codes. This approach contrasted with continental traditions and provided a model for legal reasoning that influenced emerging colonial systems. The period's emphasis on rational inquiry fostered a view of law as a human construct capable of improvement, setting the stage for reforms that sought to limit arbitrary power and promote procedural fairness. Enlightenment philosophers, including John Locke and Montesquieu, articulated principles of natural rights and separation of powers that directly informed legislative changes. Locke's ideas on inherent liberties and government by consent, combined with Montesquieu's advocacy for divided authority, inspired codifications such as the Prussian General State Laws for the Prussian states of 1794, which standardized penalties, unified regional customs, and introduced greater clarity in civil and criminal matters. These reforms aimed to reduce inconsistencies in application and enhance administrative efficiency across diverse territories. Colonial expansion during this time disseminated European legal models to regions including India and the Americas, where they were adapted to local conditions, often blending imported principles with existing practices to create hybrid systems. The industrial era, commencing around 1800 CE, confronted the consequences of rapid urbanization and factory-based production through targeted legislative responses. France's Napoleonic Code of 1804 established a unified civil framework that emphasized equality before the law, individual property rights, and contractual freedom, exerting lasting influence on civil law traditions worldwide. In Britain, the Factory Acts, initiated in 1802, imposed restrictions on child labor hours, mandated basic safety measures, and introduced inspection mechanisms to address exploitative conditions in industrial workplaces. The United States Constitution of 1787, supplemented by the Bill of Rights, created a federal structure with explicit safeguards against arbitrary authority, while international initiatives such as the Hague Conventions of 1899 began to regulate conduct in warfare. These measures collectively broadened the scope of law to encompass labor protections, including provisions for minimum wages and overtime compensation as seen in the U.S. Fair Labor Standards Act of 1938, marking a transition from punitive to preventive approaches in response to economic and social pressures. Modern specializations and human rights. Following World War II, legal development placed strong emphasis on international standards and universal entitlements, responding to widespread atrocities through foundational documents such as the United Nations Charter of 1945 and the Universal Declaration of Human Rights of 1948. These instruments established prohibitions on arbitrary detention, torture, and other severe violations, creating a global benchmark for state conduct. In the United States, the Civil Rights Act of 1964 prohibited discrimination in employment based on characteristics including national origin and sex, while establishing enforcement agencies such as the Equal Employment Opportunity Commission to oversee compliance. Comparable legislation in the United Kingdom included the Race Relations Act of 1965, which addressed discrimination in public services and employment, and the Equality Act of 2010, which consolidated protections across multiple categories into a single statutory framework. Specialized legislation emerged to address specific forms of interpersonal harm, particularly harassment and stalking. In the United States, sexual harassment in the workplace was formally recognized under Title VII of the Civil Rights Act through Equal Employment Opportunity Commission guidelines issued in the 1980s, which identified hostile work environments as actionable violations. Criminal stalking statutes originated with California's Penal Code Section 646.9 in 1990, defining repeated following or harassment accompanied by credible threats, and this model expanded to all 50 states by the mid-1990s. Bias-motivated offenses received formal recognition in the Civil Rights Act of 1968, with significant expansion in 2009 to include additional protected characteristics such as sexual orientation. Rules governing incitement underwent refinement in the United States through the Supreme Court's decision in Brandenburg v. Ohio in 1969, which confined punishable speech to that directed at producing imminent lawless action and likely to do so. Family and employment laws underwent substantial modernization during this period. No-fault divorce procedures were introduced in California in 1969, shifting the basis for dissolution from fault-based grounds to irreconcilable differences and influencing similar changes across other jurisdictions. Custody determinations moved toward the best interests of the child standard, a principle that gained prominence from the late 19th century and became dominant in the 20th century. Child labor restrictions, initially established through United Kingdom Factory Acts beginning in 1802, were federalized in the United States via the Fair Labor Standards Act of 1938, which prohibited oppressive child employment in most industries and set age and hour limitations. These developments reflected a broader re-evaluation of traditional structures, expanding protections while adapting to changing social conditions. Across these areas, modern legal specializations demonstrated a pattern of responding to identified harms through targeted statutes and international coordination. The focus shifted from general prohibitions to detailed regulations that accounted for specific contexts, such as workplace dynamics, interpersonal patterns, and familial arrangements. While core principles remained consistent, the application of these laws revealed variations in implementation across jurisdictions, influenced by differing administrative capacities and cultural priorities. This era solidified the role of law as an instrument for addressing contemporary challenges, extending protections into previously unregulated domains while maintaining continuity with foundational prohibitions. Global convergences and contemporary challenges. In the present era, legal systems exhibit increasing alignment through international organizations and agreements, as nations coordinate responses to transnational issues. The European Union's General Data Protection Regulation, GDPR, implemented in 2018, exemplifies this trend by establishing comprehensive rules for handling personal information in digital environments, addressing risks associated with data collection, storage, and transfer across borders. This regulation requires organizations to obtain consent for processing, implement security measures, and provide individuals with rights to access and delete their data, setting a standard that has influenced legislation in other regions. Similarly, amendments to United States federal law in 2013 expanded prohibitions on cyberstalking, criminalizing the use of electronic communications to cause substantial emotional distress or fear, reflecting adaptations to technological changes that enable persistent remote harassment. These developments illustrate how laws evolve to cover emerging forms of conduct that transcend national boundaries. International pacts further demonstrate convergence in addressing shared global problems. The Paris Agreement of 2015, adopted under the United Nations Framework Convention on Climate Change, commits participating countries to reduce greenhouse gas emissions and limit temperature increases, establishing mechanisms for reporting progress and increasing ambitions over time. Such agreements impose obligations on states to enact domestic measures consistent with collective goals, promoting uniformity in environmental regulation. Core prohibitions against homicide, theft, assault, rape, kidnapping, and arson maintain their foundational status, originating in ancient legal traditions yet achieving near-universal application through modern instruments like United Nations conventions and treaties. These prohibitions form the bedrock of criminal law worldwide, with consistent definitions and enforcement priorities across diverse jurisdictions, underscoring enduring human requirements for physical security and property protection. Similarities in fundamental restrictions persist across legal systems, reflecting common concerns for safety and order, while specific areas such as defamation retain historical continuity with modifications. Defamation rules, traceable to Roman law and medieval English precedents, have developed to incorporate requirements like actual malice for public figures, as established in the United States Supreme Court decision New York Times Company v. Sullivan in 1964, which protects expression by demanding proof of knowing falsehood or reckless disregard for truth. Offense-related laws, historically tied to religious prohibitions such as blasphemy, have diminished in liberal societies where speech protections take precedence, evidenced by repeals in the United Kingdom beginning in 2008 that removed criminal penalties for insulting religious beliefs. These shifts highlight how older restrictions adapt to contemporary values that prioritize open discourse over enforced respect for certain ideas. Globalization continues to facilitate alignment between major legal traditions, with civil law systems based on codified statutes and common law systems relying on judicial precedents converging on essential elements such as contract enforcement and basic entitlements. Despite this, differences remain evident, as Sharia-based systems incorporate religious principles into legal obligations, contrasting with secular Western approaches that separate law from doctrine. Emerging regulations for artificial intelligence, including the European Union's AI Act of 2024, illustrate ongoing adaptation to technological advancements by classifying systems according to risk levels and imposing requirements for transparency, accountability, and human oversight. These rules balance innovation with safeguards against potential harms, demonstrating how contemporary legal frameworks respond to new challenges while building on established principles of regulation and protection. Conclusion: the path of legal development. Exploring origins, key transformations, and worldwide convergences in frameworks. The historical development of legal systems demonstrates a continuous interaction between persistence and modification, as early imperatives for maintaining order have expanded into detailed frameworks capable of addressing present-day complexities. From prehistoric informal norms to comprehensive international agreements, laws have progressively integrated considerations of conduct and fairness, reassessing previous arrangements and extending protections to new domains. This progression highlights humanity's capacity for organized self-governance, converting initial reactive measures into forward-looking mechanisms that strengthen communal stability and reduce conflict. Enduring variations, stemming from cultural, religious, and economic differences, continue to limit complete uniformity, as observed in diverse applications of laws concerning directed conduct or family arrangements across jurisdictions. While alignment through global standards enhances consistency in judgment and enforcement, it also raises questions about preserving distinct traditions, necessitating flexible implementations that accommodate local conditions without undermining shared obligations. Ultimately, the record of legal evolution reveals an ongoing effort to achieve equilibrium in human relations, where essential prohibitions endure alongside specialized regulations tailored to evolving circumstances. As societies encounter emerging fields such as digital governance and technological ethics, legal structures must persist in adaptation, functioning as reliable instruments for resolving disputes and upholding order rather than sources of division. This trajectory supports a framework in which adjudication aligns with collective human objectives, ensuring that law remains responsive to both timeless needs and contemporary demands.